Almighty God, who in your infinite wisdom and providential goodness has appointed the offices of rulers and parliaments for the welfare of society and the just government of humankind. We beseech you to behold with your abundant favor us, your servants, whom you have been pleased to call to the performance of such important trusts in this land. Let your blessing descend upon us here in Parliament assembled, and grant that we may, as in your presence, treat and consider all matters that shall come under our deliberation in so just and faithful a manner as to promote your honor and glory, and to advance the good of those whose interests you have committed to our charge. All which we ask in the name and for the sake of our Lord and Savior, Jesus Christ. Amen. I have the following announcements. I wish to inform the House that I have received the Constitution of Zimbabwe Amendment Number 3 Bill, HB 1B 2026, from the Senate with amendments. Accordingly, in terms of Standing Order Number 190, the bill shall be recommitted to the Committee of the Whole House for purposes of considering the amendments proposed on clauses 3, 4, 7, 10, 16, 23, and 27 of the bill. I wish honorable members to recognize the presence in the Speaker's Gallery of the following honorable members from the parliaments in the SADC region and officers from the SADC Parliamentary Forum, and these are Honorable Luis Santos from Angola, Honorable Jeromina Agostino, Mozambique, Honorable Victor Pologolo, Botswana, Honorable Senator Linda Ngomado from Eswatini, Honorable Mope Kati from Lesotho, Honorable Dr. Susuwele Banda from Malawi, Honorable Monde from Namibia, and Her Excellency Buemo Sehoma, the Secretary General of the SADC Parliamentary Forum. Mr. Tofa Munashe is accompanying them as Program Manager, and Dr. S. Sigade for M&E Manager. Last but not least, Dr. M. Magaza, the media manager. There are also other staff accompanying the honorable members. Thank you. Are there any notices of motion?
Yes, Honorable Speaker.
Yes.
Thank you, Honorable Speaker. I rise to give a notice that on the 7th of July, I'll move a motion in my name mindful that youth empowerment programs are funded from public resources to benefit citizens fairly and transparently, acknowledging that the Constitution of Zimbabwe requires probity in administration of the executive programs, concerned that some communities access youth programs and development initiatives through political affiliation and party loyalty. Further concerned that such conduct undermines equality, national unity, youth participation, public trust, and proper use of public resources. Recognizing that public programs serve all citizens, notwithstanding their political party affiliations. Now, therefore, Honorable Speaker, I call this House calls upon the executive to A, introduce legislation which criminalize the political abuse, manipulation, diversion, or discriminatory distribution of public-funded youth programs and development initiatives. B, prohibit any person, public official, local authority representative, implementing agency, or political actor from denying, delaying, conditioning, or influencing access to public programs on basis of political affiliation, political opinion, or attendance to political events. E, ensure transparent beneficiary selection, including clear eligibility criteria, public notification of availability of opportunities, transparent processes, and accessible complaint mechanisms. D, strengthen oversight and accountability mechanism through Parliament, the Auditor General, and the Zimbabwe Anti-Corruption Commission, and other relevant institutions. E, provide penalties for offenders, including fines, disqualification from managing public programs, recovery of misused resources, and other appropriate sanctions. So I submit, Honorable Speaker. Thank you.
That motion appears, order, that motion appears to have escaped my eagle's eye. And it will need some sanitization for it to be acceptable. So, Honorable Member, you may need to see me so that we can sanitize it properly. Are there any further notices of motion? There is none. The clerk will read the first order of the day.
Recommittal Committee Constitution of Zimbabwe Amendment number 3 HB 1B 2026.
Thank you. The whole House will be in committee.
Order. 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 We shall begin now. The committee of the whole House will take into consideration the Constitution of Zimbabwe Amendment Bill number 3. I put the amendment proposed by the Senate Clause 3. Is there any debate? Is there any objection? Yes, Honorable Leader of Government Business. Thank you, Honorable Chair. Honorable Chair, the amendments were proposed by the Senate, and it's only fair that I speak to what the Senate did. And before I do that, Honorable Chair, allow me just to make a few clarifications. Honorable Chair, there have been suggestions in some sections which are false and misleading reports that this bill has been recommitted to this Honorable House because it was found to be riddled with mistakes, and therefore we were here to correct the alleged mistakes. I think I should put the record straight so that we all move in the same direction. Honorable Chair, nothing could be further from the truth. We are here because the bill, having been overwhelmingly passed by the National Assembly, was considered by the Senate, and the Senate, in the exercise of its constitutional function, made amendments to it. And those amendments have been recommitted to the National Assembly for reconsideration. And, Honorable Chair, that is the ordinary working of a bicameral parliament with 2 chambers. And it is nothing more than that. And we must applaud the Senate that they are doing their work. It's not a rubber stamping body. And allow me, Honorable Chair, allow me a brief moment to place 3 matters on record. It's just to correct the record. First, this bill was gazetted by the Speaker on the 16th of February. It lay in the public domain for more than 90 days before it received its first reading in the National Assembly on the 2nd of June. Throughout that period, it was the subject of close, animated, and extensive public commentary. And in all that time, not one error or a mistake was pointed by anyone. A bill that has stood before the nation for more than 90 days cannot fairly, Honorable Chair, be described as having been riddled with mistakes, when not a single mistake was pointed out during its public scrutiny. And secondly, when the National Assembly debated this bill across many days and many contributions in
Order, Honorable Minister. Order, Honorable Makumire. Order, Honorable, in the order. This is an August House. We don't kill ourselves like that. Can you switch off that mic there? Who switch on that mic? Please, may you switch off? Can you switch off that mic? Thank you very much for being an honorable member. Order, honorable members. Order. Honorable Minister, please carry on.
Thank you, Honorable Chair. Honorable Chair, I was saying that when the National Assembly debated this bill across many days and many contributions in 7 sittings, no member on either side of the ISO pointed to a single error or a mistake in its text. And thirdly,
on a point of order.
Senate.
On a point of order. Point of order.
Order, Honorable Minister. What's your point of order, Honorable members? What's
point of order, Honorable Chair. Honorable Chair, the Leader of Government Business does not need to respond to social media aspersions. In this August House, these issues were not raised. There is no need to respond to them in this August House. You cannot waste our time by responding to rumors from the social media. If he is worried, he can do a press conference. It's all in good order.
Order. Honorable Molokeli. Order. The minister, order, can you listen to me? The Minister of Justice and Legal Affairs is leader of government business in this house. And therefore, listen, therefore, if ever there's anything that taints the business of the house, it is very correct for the minister to set the record straight. We don't want distortions here. We don't want hearsay here. The Honorable Minister, as leader of government business, he has the capacity and within his right to clarify issues that are of pertinent importance to this house. So allow him to finish off.
The issue...
Hey, Honorable Molokeli, please, Honorable Molokeli, please take your seat. Please take your seat. Honorable Molokeli.
In fact, he must tweet.
Can you be guided by...
You can give Rutendo Matiarare. You can tweet.
Honorable Makumire. That's the first warning over there. Honorable Minister, please to carry on.
Thank you, Honorable Chair. Honorable Chair, I was saying that it is the Senate applying itself to the bill with great care that identified the refinements that are now before us. Some senators brought their observations to me, and I adopted them and tabled them, while other senators tabled their own amendments. That is precisely the work for which a second chamber exists. It is not a mark of carelessness. It is the system of two chambers working exactly as they are meant to work. In so doing, the Senate has put to rest the tired claim that it is no more than a rubber stamp. What is now described as the correction of mistakes is in truth one house completing and refining the work of the other. With that clarification, Mr. Chairman, Honorable Chair, I turn to the amendments made by the Senate which are contained in the bill. On clause 3, Honorable Chair, the first amendment is to clause 3, which provides for the election of the president. The Senate has refined section 92, subsection 5, which governs the conduct of that election in the form that the National Assembly passed. The subsection provided that ZEC would preside over the election and that the procedure would follow the standing orders of Parliament. The amendment provides instead that the election shall be conducted by ZEC in accordance with the electoral law and the standing orders. The refinement, Honorable Chair, the refinement is one of precision. ZEC will conduct the election, not merely preside over it. And an election of this constitutional importance should rest not on the standing orders of Parliament alone, but also the electoral law, which will be aligned to the manner in which the President is elected in Parliament, and the amendment secures that footing. I therefore move that the amendment be adopted, Honorable Chair.
Thank you. Thank you, Honorable Leader of Government Business. Is there any debate? I put the question that the amendment proposed by the Senate be now made. Those of that opinion will say aye. Aye. Those of the contrary opinion will say no. I think the ayes have it. The ayes have it. The question is accordingly affirmed, and the amendment is hereby made. I put the question that clause 3 is amended by the Senate stands part of the bill. Those of that opinion will say aye. Aye. Those of the contrary opinion will say no. I think the ayes have it. The ayes have it. The question is accordingly affirmed, and clause 3 is amended stands part of the bill. I put clause 4. I'll put clause 4, Honorable Mshoriwa.
Thank you, Mr. Chair. Mr. Chair, I've gone through the proposed amendment by Senate, which seeks to delete clause 94, subsection 3. And for the benefit of the House, this subsection reads, a vice president who becomes president on the death, resignation, or removal from office of the president assumes office when he or she takes before the Chief Justice or the next most senior judge available the oath of president in the form set out in the third schedule, which oath he or she must take as soon as possible, and in any event within 48 hours after the office of the president becomes vacant. Mr. Chair, Senate proposes to delete this clause and to delete the current provision of the Constitution. My view, Chair, is that I disagree with that proposal. I actually believe, Chair, that whenever there's a vacancy in the office of the president, and it doesn't matter whether the parliament, the current provision in the CAB 3 says the parliament should then sit as an electoral college after the passing on or the removal of office from a president after in about 2 weeks. But in the meantime, a country cannot afford not to have a president. And the vice president, whom I understand from the amendments, is the last vice president that acted, surely should take an oath, should take an oath for that time frame, even if it means 1 week. The reasons is simple. Firstly, like I said, you cannot have a situation where that vice president, in that 2 weeks, you have the power and the functions of the executive president. So in as much as that vice president is not going to be there for a longer time, but because he or she is going to occupy the office of the president, be it 2 weeks or less, but during that course of time, he or she should actually take an oath. So the current provision as it stands in section 94.3, which I read, I think is actually correct. And in my humble view, there's no need for us to remove it. It should actually remain unless we are saying that we want someone to take over and then that person does not take an oath. Because that person should just take an oath because you are a president, albeit for a very short period of time. So to that extent, Mr. Chair, I move the amendment standing in my name that we reject the recommendation from the Senate.
Further debate.
Honorable Chair.
Order. Let me just finish this part. I put the amendment proposed by Honorable Mshoriwa.
I need to respond.
Yes.
Clarify before you do that.
I was going to say, is there any debate, then you
Because if
come
you
in.
put it and it's rejected, it becomes mute. There's no need for me to respond. I need to respond so that when you put it,
I also need to
that
debate.
Reject and.
Sorry, Honorable.
I think what is fair, Honorable Chair, is I should be able to explain the amendments.
Yes, I'm actually putting the question for debate, Honorable Leader of Government Business, so I'm not closing it off. Like I was saying, I put the amendment proposed by Honorable Mshoriwa for the deletion of clause 4. Is there any debate? I recognize
Yes.
Minister.
Honorable Chair,
Order. There's two
Honorable
debates.
Chair, just
Can you allow?
You get your chance.
There's
Order,
debate.
order, you get your chance.
There's a procedure here, man.
Order. I've recognized the leader of government business. You get your chance. Order. You get your chance. So relax. Order. Honorable leader of government business, please carry on.
Honorable Chair, Honorable Mshoriwa does not understand what we are doing here. This clause is no longer effective. Even if we don't remove it, it was not even effective currently. When we did amendment number 2, we removed this. We even indicated that upon a vacancy existing, the party would then choose where the president came from, the successor. So this is a cleaning up exercise. And in any event, when there is a vacancy, if the president cannot continue for whatever reason, you don't swear in somebody to act. There is a provision in the Constitution for an acting president pending the election of another president. So you don't, an acting president does not take an oath of office as if that is the actual president. So we are just doing the cleaning up of the Constitution by removing redundant clauses. In other words, what we could have opted to do is not to inform Parliament and requested the law reviser to remove it because it was dealt with. So what we are simply doing in this new clause is to make provisions that are current and consistent with what we did in CAP 3, which is what I'm going to do, to read to honorable members so that they can debate from a point of knowledge. Clause 4 is a new clause, Honorable Chair, which was not contained in the bill that we passed here. It amends the section dealing with the assumption of office by the president and vice presidents following an election by repealing section 94 subsection 3 of that section. And the reason is one of good order. Section 94 provided for a vice president who became president upon a vacancy to take the oath of office, which is what we deleted in CAP 2. That provision no longer applies. When Parliament passed amendment number 2 in 2021, it removed the automatic elevation of a vice president upon a vacancy in the office of the president. This bill now provides that upon such a vacancy, Parliament elects a new president within 30 days. Within 30 days, the old subsection, therefore, has no further work to do and is accordingly removed so that the Constitution does not continue to carry a provision the law has already left behind. That's the reason. I so move that the amendment proposed by the Senate be taken into consideration, I think.
Debate.
Debate. Thank you, Honorable. Sorry, Honorable Gumbo, switch off your mic. Why? Right. Like we said, you can take a seat. Like we said in previous sittings, if you want to debate, please stand up and indicate that you want to debate without switching on your mic, and I will definitely then give you the floor to do so, so that we don't disturb the technology that is happening here. So is there any further debate? I recognize you, Honorable Morokeli.
Thank you so much, Honorable Chair. I need to raise a point of concern to this August House. During the debate of the Constitutional Amendment Bill number 2, I was concerned about the decision to remove what we call Section 92 of the Constitution, which under the 2013 Constitution is known as the running mate clause. The decision to remove it was not in the best interest of this country, especially from a security point of view. And now today,
Point of order.
we are...
Point of
Can
order,
I-
Honorable Chair.
Order.
Point of order.
Order.
Just to clarify so that we can debate from a point of knowledge.
Order. The honorable member has not been stopped from debating. The honorable leader of government business has just put a point of order to clarify. He will still go on and debate. Order. Yes, honorable leader of government.
Honorable Chair, CAP 3 did not remove the running mate. So we cannot debate something that was removed 4 years ago, and you raise concern now. I think that is not in order. We cannot waste our time here debating things that were removed 4 or 5 years ago.
Order. Honorable Molokele, I hope you heard that. And
yeah, but he misunderstood me. I never spoke about CAP 3. I spoke about CAP 2.
Order. What the leader of government business is simply trying to say is that we cannot debate something that happened years ago. Right? So, stick to this clause as proposed by order. Can you stick to this clause as proposed by Honorable Mshoriwa? Please, go ahead and stick to the clause.
Honorable Chair, I think this is not fair. I'm trying to present an argument. You are giving us an opportunity to debate. Before I finished presenting my argument, someone disrupts me and totally misleads the House.
I have said continue, so don't delve into those issues.
Okay.
I've made a ruling. Continue.
What we are dealing with is a legal lacuna that was created by a short-term decision of removing Section 92 of the original 2013 Constitution under the Second Amendment Bill. What we are trying to address using an administrative process is still not going to be adequate. The reason why we had Section 92 in the original 2013 Constitution is because we knew that in case of an emergency, in case of a sudden death, in case something happens to the incumbent president, we would immediately saw in one of the vice presidents to take over the country. Even if a war started the same day, he would have immediate authority and power. The real reason why we did that is to protect the national security and integrity of this country. Under this current system, I need to educate the House. Under this current system,
Order, honorable members. Order. Let's listen to him.
Under this current system, we have a legal lacuna that could lead to a constitutional crisis, that could lead to a national political instability and insecurity. There is a difference between an acting president who is acting as an acting president because the current president is alive and well, maybe he's traveled out of the country, and an acting president who is acting in the aftermath of the original incumbent. Those positions are not the same. If the president of the country leaves today to attend a conference in Zambia, he appoints one of the two vice presidents in an acting capacity, but he remains as the de jure and de facto president of the country. So, what the honorable leader of government business is addressing is an administrative issue that has no constitutional relevance or validity whatsoever. What it means is
honorable members, order. Honorable Mutodi, do you have a point of order?
Thank you, Honorable Chair.
Honorable member, the honorable member seated there, you keep on switching on your mic there. Yeah. Go ahead, Honorable
Chair. Thank you very much. I think Honorable Molekele is a legal practitioner, knows that the clause that has been referred by Honorable Mshoriwa.
I can hardly hear you.
I'm saying, yes, Honorable Chair, let me increase my voice.
Order, honorable members, I need to hear the point of order. Please, can you keep quiet? Let's hear what Honorable Chodi wants to say. Honorable Chodi, go ahead.
Yes, what I'm saying, Honorable Chair, is that the proposal being made by Honorable Mshorewa is at law what we call a brutum fulmen. It is a brutum fulmen in the sense that the provision has already been taken over by events. By virtue of Cap 3 being adopted by this parliament, it means that that provision is now a brutum fulmen. And on the logical part of it, Honorable Chair, given
Order, Honorable Mdori.
That is debating.
Order. Musalame mjiko zwanza mamaki babo. Honorable Mangana, Honorable Magumire babo. Zimai magenye. Musatame mchidaroga. Aywa. Honorable Mdori. Your point that you are bringing is a point to make in a debate. So we'll give you a chance to respond to that. You have a point.
Thank you, Honorable Chair.
Honorable Mulugele, please go ahead.
Thank you so much, Honorable Chair. I wanted to make sure that it's very simple and straightforward. We need to be consistent. As I speak to you this afternoon, we have got what we call a deputy minister and a cabinet minister. As we speak this afternoon, there is not even one deputy minister who is allowed to be an acting minister under whatsoever circumstance. There is a reason, there is a logic behind that. When you are a deputy minister, you are not the substantive minister. That's why even if the substantive minister is on leave, the deputy minister cannot be the acting minister. Using the same logic, you do not expect someone who became a vice president because the president was still there to be allowed to be acting president in replacement of a substantive president. That means that they automatically have the same powers that a de facto president has. In the same way you are refusing that a deputy minister be an acting minister, you should not then allow an acting vice president to be an acting president in the same capacity as a de facto and de jure president. It means they need to be sworn into office so that if the country starts a war with Zambia tomorrow or Zambia attacks Zimbabwe, they have to make decisions just like a substantive president, just like a substantive minister. So this logic is fundamentally flawed. It also does not address an issue of concern. What if the last acting vice president decides to say that I want to be the president of this country? What will you do about it as parliament? What if he dissolves parliament? What will you do about it? You will be dissolved as parliamentarians by an acting president who has not even sworn in. This is a constitutional crisis that we are creating.
Order.
So what I'm saying.
Order. Honorable members, stop playing with your microphones, please. Honorable Molokeli, can you wind up now?
What I'm trying to help us to understand is that by trying to address a constitutional matter using an administrative process, we are like trying to create a constitutional crisis that will come and haunt us as a country tomorrow. That last sitting acting vice president, the vice president who was last acting as president, cannot be given the same level of power with an acting president who is replacing an incumbent president. So that is the legal misfortune or legal mischief that you are trying to create. And I'm urging the honorable leader of government business to sit down and thoroughly understand the implications. Because if I'm the last acting president, I'll just run with this thing. I don't need parliament to vote for me. I'll just run with it. Thank you so much.
Any further debates? I recognize Honorable Mtodi.
Thank you, Honorable Chair. Let me refer to
Order. Can the Honorable be heard in silence, please?
Yes. So, Honorable Chair, the clause alluded to by Honorable Mshorewa is a brutum fulmen at law. It has already been taken over by events. The proposed law by CAP 2 might not be favorable to some of the honorable members, but it remains law by virtue of it having been approved by this parliament as part of that constitutional amendment provision. So the clause has been taken over by events and should not be smuggled into this parliament as an afterthought. I also want to address the logic that is being forwarded by Honorable Molekele, saying that an acting president...
Point of order, Honorable Chair.
Cannot...
Order.
Point of order, Honorable Chair.
Order. Sit down. Yes, what's your point of order?
Honorable, the duty to respond to other members' debate lies with the lead of with the Honorable Minister. Honorable Mtodi has no prerogative to respond to any other member here. May he just debate then the minister should be given time to respond.
Order. Order. This is an august house, and what Honorable Mtodi is doing is what we call a debate, and it's very much allowed. All right. Honorable Mtodi, go ahead.
Thank you, Honorable Chair. My last point was to address the input from Honorable Molekele. Honorable Molekele does not take cognizance of the fact that...
Point of order. I need to be protected.
Taking an oath of office.
That's unprocedural. You can't respond that. You are not a minister. You can't respond. You can debate your view, but you can't respond personally.
Honorable Molekele, you can't abuse the house like that. What's wrong with you? It's not correct. Aye. How is it done? Asiyenzi njalo. Sidabuka sonke asenzi njalo. Order. Honorable Mutodi, please wind up.
I had already winded up saying that the input by Honorable Molekele is not taking cognizance of the fact that vice presidents, as they currently exist, still act as presidents even without taking oath of office. So giving a caretaker president sweeping powers even to declare war and to take oath of office would be misleading and would actually create chaos. So the current input of the law as proposed under Cap 3 should be upheld, and the proposal by Senate should be adopted by this House. I thank you, Honorable Chair.
Thank you. Any further debates? I recognize the government chief whip.
Mr. Chair, my observation is succession issues are on clause 7. Why don't we deal with this? Because it's only removal. Then we go to succession issues on clause 7. Then we debate what they want to debate.
Thank you, Honorable Government Chief Whip. At times, order. At times, I wish that honorable members, before we come to the House, we go through these things. They will actually guide you to say, at times we just waste time unnecessarily when a certain issue is already at stake somewhere. Like what the government chief will be saying, most of these issues that I'm talking to are actually contained in clause 7. But anyway, is that a further debate? Yes, Honorable Gumbo, go ahead.
Thank you, Honorable Chair. Honorable Chair, Section 94 of the Constitution speaks to the assumption of office by the President and Vice President. And what it does, contrary to the sentiments passed by the Minister that subsection 3 is an inconsequential clause of the current Constitution prior to the amendment, is rather insincere and incorrect. In fact, the Minister says he's cleaning up the Constitution is in fact contaminating the Constitution. And I'll make my point, Honorable Speaker, Honorable Chair. We don't read the Constitution or constitutional clauses in isolation. Constitutional clauses speak to each other. Section 94 on the assumption of the presidency makes two separate but significant suggestions which speak to two other clauses which I'll make reference to in my submission. Section 94 subsection 1 deals with the person who has been elected president. That person must then take oath of office, so on and so forth. Section 94 subsection 3 speaks of a different scenario under which or through which a person can assume the office of president. Section 94 subsection 3 must be read in conjunction with section 101 of the Constitution, which speaks to the issue and question of succession. So already the drafters and the framers of this Constitution and this clause were making a futuristic positive assumption that there will be a situation where the transition of the presidency will be subjected to a succession question or process. So subsection 3 deals with that. That's why it starts by saying where a vice president assumes. Now, I want to take this House to section 143 subsection 1, and I hope the minister is following. Section 143 subsection 1 of the Constitution. You see why these two sections in section 94 speak to different scenarios. Indulge me as I go to this section. Section 143 subsection 1, Mr. Chair, says that Parliament is elected for a 5-year term which runs from the date on which the president-elect is sworn in and assumes office in terms of section 94(1)(a). So, the life of Parliament is tied to the election of the president and the assumption of office in terms of section 94 subsection 1. With the current amendment that is proposed to remove section 3, what the minister or what Senate has proposed is to say, let's remove an alternative way that the president can assume office. And consequently, or the consequence of that, is that when a person assumes office in terms of section 94(1)(a) alone, section 143 of the Constitution is affected. Parliament will renew every time a president resigns, dies, and a vice president takes over office in terms of section 94(1)(a). So you do not, you do not seek to remove an alternative method of assuming office without affecting section 143 subsection 1, which says the life of Parliament runs for 5 years, or for the years that it runs, is proposed now 7 years after the assumption of office by the president. I so submit. Order. Minister.
Is there any further debate?
Minister. If I am wrong,
Order, Bugumbo, you debated like an honorable learned counsel. Why now wanting to behave like a hooligan? Huh? Honorable Mshoriwa, you want to debate? Okay. Honorable Minister, I'll come to you. Let's exhaust Honorable Mshoriwa first.
Yeah, Mr. Chair, I listened to the Honorable Minister.
No, he can still debate. He just moved it, but he hadn't debated it.
No, remember, I moved the amendment, Mr.
Yes, you can go ahead and debate.
Mr. Chair, I listened to the response from the Honorable Minister objecting to my amendment. But I want to just state that the oath of office is a constitutional prerequisite for the lawful exercise of the presidential powers. In my view, it is not a mere formality, but a constitutional commitment to uphold and defend the Constitution. Secondly, Mr. Chair, the duration of service is irrelevant. Whether the acting president serves for 2 weeks, 1 week, the office being exercised by the acting president is that of a president and must carry the same constitutional obligations. And thirdly, Mr. Chair, dispensing with the oath creates an unnecessary constitutional exception and risks undermining the legitimacy of decisions taken by a person exercising presidential authority. Because what we are basically saying is that if a person is in that office without taking an oath, we are literally undermining the decisions. Then, Chair, it is my view that retaining Section 94.3 as it is preserves constitutional certainty and reinforces the accountability and maintains the dignity of the highest office of the Republic. Honorable Chair, the Honorable Minister maybe is actually taking this from a simplistic point of view. A vice president who is going to act even for 10 days, 10 days, and all of us know as politicians that 1 week in politics is a very long period. And 10 days of someone acting in the office of the president is a long period. Certain decisions can be made. And we don't want this person to just get into the office without taking an oath. Zimbabwe needs to have confidence in the office of the president. Then the last three, before I sit down, the Honorable Minister, in his submission, he had actually said that it doesn't matter who could actually have left this section as it is. In that view, then I think the best thing is to leave 94.3 as it currently is. And I think no one suffers anything. I think this would be the best for the country.
Is there any further debate? Yes, Honorable Zobo.
Mr. Chairman, I think Honorable Member is failing to distinguish, Honorable Mushoriwa, is failing to distinguish between two things. He is failing to distinguish between an acting president and an actual president. He seems to see these as equivalent. What the minister has made very clear is that on the death or vacancy in the presidency, the person who acts as acting president is the vice president. Now, he is equating the office of an acting president with the office of an actual president. And I think that is the flaw in his argument. Thank you. So I said.
Thank you. I recognize the Honorable Leader of Government Business. Please switch off your mic, Honorable Zobo. Thank you. Switch off your mic. Right. Yes, Honorable Leader of Government Business.
Honorable Chair, Honorable Zobo is very correct. And we must read Section 94 the way it is reading. It says a vice president who becomes a president, not acting. We no longer have a vice president who becomes the president automatically. So this is irrelevant. I don't see what we are debating, because it's saying a vice president who becomes president on the death. We don't have a vice president who automatically assumes the presidency anymore. Whether it was wrong or right, but it's no longer in our statutes. So we are simply deleting what is no longer relevant. So whether you argue whether it was correct what we did or not, it's neither here nor there. The Constitution is saying a vice president who becomes a president. And the Honorable Gumbo was animated, he went to 101. It states that upon the death, a vice president who becomes acting, and we have a whole chapter on the powers of an acting president. And it stands as it is, nobody is challenging it. I propose that we move, Honorable Chair.
Thank you, Honorable Leader of Government Business. Order. 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 I put the question that the amendment proposed by Honorable Mshoriwa be now made to delete clause 4. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the noes have it. The noes have it. The question is accordingly affirmed, and the amendment to delete clause 4 is hereby negatived. I put the amendment proposed by Senate of clause 4. Is there any debate? I call upon the Honorable Minister. Honorable Minister, you had already addressed that issue. Do you want me to put the question?
Thank you, Honorable Chair. Honorable Chair, I put the amendments as proposed by the Senate on clause 7. Clause 7, Honorable Chair.
Sorry, it's clause 4. It's clause 4. We're doing the
Type it.
We're first dealing with the Honorable Mshoriwa's submission. Now, so we can put the question. Thank you. Right. I put the question that the amendment proposed by the Senate be now made. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it. The ayes have it. The question is accordingly affirmed, and the amendment is hereby made. I put the question that clause 4, as amended, stands part of the bill. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it. The ayes have it. The question is accordingly affirmed, and clause 4, as amended, stands part of the bill. I put clause 7. Where is it? I put clause 7, amendment of section 101 of the Constitution. Is there any debate? The Honorable Minister? It's okay. Okay. I put the question that the amendment proposed by the Senate be now made. Those of that opinion will say aye.
No, Chair. You are supposed to go for a debate. You didn't go for a debate. You are supposed to go for a debate. That is the procedure.
Order.
We are ready to debate.
Order.
You didn't go for debate.
Order. Order. Switch off your mic, Honorable Mshoriwa. We are not fighting. Order. Yes. Order. Take your seat. Relax. Breathe. Right. I asked for debate, Honorable Mshoriwa. Maybe you did not hear. It's okay. We are not yet lost. All right. Relax. Unelagi nokuthi community stage la ekudzinga yoyo. Oh yeah. Honorable Mshoriwa, do you have any debate on this?
Yes, I do have a debate.
Okay, I recognize you.
Thank you, Chair. Chair, I've also looked into the amendment by Senate on clause 11. I don't have a problem with the text, except that I think for the...
sorry, did you say clause what?
Clause 7.
7, okay.
Yeah.
I thought I had 11.
No,
okay.
It's 7.
Fine,
so
thank you.
what I was going to propose, Chair, to the Minister, is that we add the words to after the submission by the Senate to say assumes office in terms of section 92, then we continue to say up to expiry of the former presidency term. And the reason is just for clarity, to make sure that this person is going to act is going to be president up to the end of the term of the former president. So his or her job is to finish the term. So I wanted to make sure that for completion, let's include up to expiry of the former president's term on what the Senate has proposed.
Any further debate? I call upon the Honourable Minister. Do you want to respond?
Honourable Chair, Honourable Mshoriwa has confused himself because we amended and we said in the bill, if he read the bill that passed through this August House, it says if there is a vacancy, Parliament will sit within 30 days. He left that standing and introduced another amendment that will conflict with one that he has left standing. So I think let's put the amendment proposed by the Senate. I thank you.
Thank you, Honourable Minister. Order. Honourable Mshoriwa, it's all right. Sit down. There's no animosity at all. Don't worry. There's no animosity. I put the question that the amendment proposed by the Senate be now made. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it, the question is accordingly affirmed and the amendment is hereby made. I put the question that clause 4 as amended by clause 7, as amended by the Senate stands part of the bill. Those of that opinion will say aye. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it, the question is accordingly affirmed, and clause 4 as amended stands part of the bill. Right, I put clause 10, I put the amendments proposed by the Senate of clause 10, amendment of section 143 of the Constitution. Is there any debate? No? 11. Just a moment, honourable members. A small administrative glitch. Order. Let's have all members taking their seats, please. Honorable Chigumbu and Honorable Tsvangirai, take your seats. Right, we move on. I put the amendment proposed by the Senate of clause 11, amendment of section 145 of the Constitution. Is there any debate? Honorable Moyo, are you standing up to debate? Okay. Yes, Honorable Mushorwa.
Yeah, Chair. On clause 11, Chair, I had proposed an amendment. Chair, according from the Senate, it says after a general election, the first sitting of Parliament.
Order. All right. Sorry. Yes. Take your seat. Switch off your mic. No, sorry. Our humble apology. I see that you had proposed for an amendment for deletion, right? Oh, for substitution, all right. Okay, so let me put the question again. I beg your pardon, honorable members. I put the amendment proposed by the Honorable Mshoriwa of amendment of clause number 11, which is now number 10. Yes, I recognize you, Honorable Mshoriwa.
Yeah, Chair, the proposal here is saying that after a general election, the first sitting of Parliament must take place at a time and on a date determined by the Clerk of Parliament in a notice in the Gazette, but not later than 14 days after the election results have been declared. Chairman, I want to submit my amendment. My amendment is very simple. My amendment says, under this proposed constitutional bill number 3, Zimbabwe will always have a sitting president until Parliament elects a successor. There is therefore no constitutional vacuum requiring the Clerk of Parliament to exercise this executive function. Summoning Parliament, Mr. Chair, is a fundamentally an executive constitutional function that should remain vested in the President rather than an administrative officer. The Clerk of Parliament is the chief administrative officer of Parliament and should not be assigned powers that properly belong to the executive. Allowing the President to summon Parliament preserves the constitutional separation of powers while permitting the clerk to perform the administrative tasks associated with convening the sitting. This approach, Mr. Chair, maintains constitutional consistency by ensuring that the executive authority remains vested in the head of state and government until a new president is duly elected by Parliament. So what we are basically saying is that instead of the Clerk of Parliament summoning Parliament, the head of state or the incumbent president should actually summon Parliament. And maybe that will be one of his last duties as the sitting president. He summons Parliament. Parliament comes, then elect a president. But to then say that that president will be now a lame duck president just seated in the office, does not have even power to then do such a simple task. So my view is that we need the incumbent president to do. But further to that, Mr. Chair, you need also to understand, I've actually been checking within the various jurisdictions. I've not come across such a proposal. And this is one issue that I think the Honorable Minister needs to consider. To simply say, we have a president. There will not be a day in this country where we cannot have a president in office. Unless we are basically saying, no, that president will be a president who will vacate office because an election of Parliament has happened. It doesn't happen like that way. I so move, Chairman.
Thank you. Any further debate? Yes, I recognize.
Thank you, Mr. Chair. Honorable Chair, we are faced with a situation where the function of the process from after election for us to elect a president rests with Parliament. And the Clerk of Parliament just gives a notice. It's not going to do anything, but it just gives a notice. Maybe for a lighter moment, I would say, Honorable Mshoriwa, if the present president decides not to call parliament, what do you do? The president who is current, and we are bringing in another president, and he has the function, he has the authority to call parliament, and he decides not to call parliament, what will you do? So, an independent someone who have no interest whatsoever with the presidency would be the best person to guarantee that parliament will be called.
Debate.
Thank you, Honorable Government Chief Whip. Order.
Debate.
Right. Yes, Honorable, I recognize you.
All right, Chairperson. I think I would want to agree with the government chief whip that the president that is going to be replaced will obviously be now a conflicted president. And it makes sense if you look even at from South Africa. It's the clerk actually who calls the parliament to come and sit so that they can perform the. So I'm supporting this, but my only problem, Honorable Chair, my only problem is with.
Order, honorable members. Honorable members on my right, order.
My only problem is with the 14-day period. I think it's too long. I would want to suggest that I think a 7-day period will be sufficient. You know, that's my proposal. Thank you.
Thank you. Is there any further debate? Right. I put the question that the amendment proposed by Honorable Mshoriwa be now made. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the noes have it. The noes have it. The question is accordingly affirmed, and the amendments proposed by Honorable Mshoriwa are negatived. I now put the amendment proposed by the Senate of clause 11, amendment of Constitution, amendment of section 145 of the Constitution. Is there any debate? No debate. I put the question that the amendment proposed by the Senate be now made. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it, the ayes have it. The question is accordingly affirmed, and the amendment is hereby made. I put the question that clause 11, as amended by the Senate, stands part of the bill. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it, the ayes have it. The question is accordingly affirmed, and clause 11 as amended stands part of the bill. I put the amendment proposed by Senate of clause 16, amendment of section 163 of the Constitution. Is there any debates? No debates. Is there any objection? No objection here too. I put the question that the amendment proposed by the Senate be now made. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it, the ayes have it. The question is accordingly affirmed, and the amendment is hereby made. I put the question that clause 16, as amended by the Senate, stands part of the bill. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it, the ayes have it. The question is accordingly affirmed, and clause 16 as amended stands part of the bill. 23. I put clause 23, I put the amendment proposed by the Senate of clause 23, amendment of section 232 of the Constitution. Is there any debate? No debate. Any objection? No objection heard of. I put the question that the amendment proposed by Senate be now made. Those of that opinion who say aye. Those of the contrary opinion who say no. I think the ayes have it, the ayes have it. The question is accordingly affirmed and the amendment is hereby made. I put the question that clause 23 as amended by the Senate stands part of the bill. Those of that opinion who say aye. Those of the contrary opinion who say no. I think the ayes have it, the ayes have it. The question is accordingly affirmed and clause 23 as amended stands part of the bill. I put clause 25, I put the amendment proposed by the Senate, that clause 25, amendment of section 243 of the Constitution be now made. Is there any debate? No debate. Any objection? No objection agreed to. I put the question that the amendment proposed by the Senate be now made. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it, the ayes have it. The question is accordingly affirmed and the amendment is hereby made. I put the question that clause 25 as amended by the Senate stands part of the bill. Those of that opinion will say aye. Those of the contrary opinion will say no. I think the ayes have it, the ayes have it. The question is accordingly affirmed and clause 25 as amended stands part of the bill. Thank you, Order. I shall now report the bill with the amendments proposed by the Senate to the Speaker.
Order. Order. Can you take your seats?
Mr. Speaker said, the Committee of the Whole House has gone through the Constitution of Zimbabwe Amendment Bill number 3, HB 1B of 2026, as set forth in the accompanying copy, and has agreed to the same with amendments proposed by the Senate.
Thank you. The chairperson of the committees reports the Constitution of Zimbabwe Amendment number 3 Bill, HB 1B 2026, with amendments as proposed by the Senate. What day for third reading? Honorable Minister.
With the leave of the House now, Mr. Speaker, sir.
Thank you. Section 328, subsection 5 of the Constitution of Zimbabwe provides that a constitutional bill must be passed at its last reading in the National Assembly and in the Senate by an affirmative vote of 2/3 of the membership of each House. In order to comply with the provisions of Section 328, subsection 5, it is necessary. Can you sit down, please? In order to comply with the provisions of Section 328, subsection 5, it is necessary that the number of affirmative votes cast by honorable members be recorded. In terms of the voting process, bells will be rung for 7 minutes to enable honorable members who are within the premises of Parliament to make their way to the chamber. At the expiry of the 7 minutes, all the honorable members will be expected to be in the chamber and the doors will be secured. Order. Order. No member will be allowed to enter or leave the chamber before the actual voting. We'll first ascertain the number of honorable members in the chamber, and thereafter the voting process will commence. Honorable Engineer Magwa, can you listen? During the voting process, the tellers of each side will be assisted by the clerks at table and the officers from the Sergeant at Arms. I expect honorable members to cooperate so that we conduct the voting in an orderly manner. I therefore direct that the bells be now rung, after which the votes of the honorable members will be counted.
members, order. Take your seats, please. Time up. Right. Honorable members, take your seats. Order. The motion over which the House shall divide is the question that the Constitution of Zimbabwe Amendment Number 3 Bill, HB 1B 2026, be now read a third time. The ayes will file to the right-hand side of the chair, which will spread up to where the Sergeant-at-Arms is standing. Order. Order. The noes will file to the left-hand side of the chair, which will be the right side of the Sergeant-at-Arms. Each side must choose its own two tellers to do the counting of honorable members voting on their side. Can the tellers please take position? Two tellers on either side, and the clerks at tables will join them. Order, order, order. Now, to avoid recounting and recounting, we'll take, starting with the members on my right, from where the Sergeant-at-Arms is, you count that cluster and you agree. You come to the next cluster, you agree. The next cluster, you agree. And finally, this cluster on my extreme right. You do the same for the cluster on my left. Please proceed. Please proceed. Please, once you have agreed, can we move to the next cluster? Right. Are you ready? Just a minute. You have finished the counting now. Can you proceed to cross out the names? Divide yourselves, don't follow each other. Honorable Mateo, please start. Tellers on my immediate left. Tellers on my immediate left. Can you move? Clerk of Parliament, can we have progress, please? What is the issue? Clerk, what is the issue? What is the issue?
Like I'm saying, they can't account for one person. So I said they should.
Who is that one person?
It's coming, we can't pick out count and see if we have the 267 that you put. Because I suspect we called the Minister of Justice. Then we count the number of people present.
Minister of Justice is an appointee.
Yes, an appointee. Unlike the others who moved, he remained in this seat, so we may have great material that was taken.
So they are counting now.
They're counting, so
And then what happens with the cross-checking? We go back to councilman again. The names.
no, we will pick the name.
Tellers, please. It's either you didn't do arithmetic at school or not. You are taking too long. Okay, can we have the teller announcing on my left? Take position. Teller on my left. Teller on the right.
The nose to the left.
Just a minute. Right. You want to proceed? Yes.
The nose to the left, total number 41.
On the right, order. On the right.
Yes, to the right, 226.
Zayendwa. Order. 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 Honorable members, on my right, please, let's have order. I have not yet announced the results formally. If you want to sing and sing outside there when I have announced it. Yeah. Thus, the result of the count is that 226 honorable members have voted in favor of the third reading of the bill, and 41 have voted against the bill. The number of the affirmative votes recorded is not less than 2/3 of the membership of the National Assembly. I therefore declare the final votes in the National Assembly on the Constitution of Zimbabwe, Amendment number 3, Bill HB 1B 2026, to have been in accordance with the provisions of Section 328, subsection 5 of the Constitution. The clerk will read the bill a third time.
Constitution of Zimbabwe Amendment number 3, HB 1B 2026.
The Honorable Minister of Justice and Leader of Government Business.
Thank you, Mr. Speaker, sir. Mr. Speaker, sir, before this Honorable House rises, allow me a few words, Mr. Speaker, sir. And it should be placed on record that what the House has done is momentous. Mr. Speaker, it is historic. Mr. Speaker, it is historic, and these are not words I use lightly, Mr. Speaker, sir. They are often easily spent and rarely end. Yet, here they are, deserved, and the years will bear them out into posterity. I thank first, Mr. Speaker, His Excellency, the President, on whose summons the House returned to finish its work. Mr. Speaker, sir, I thank you for the steady and experienced hand with which you have brought these proceedings to their close. My deepest appreciation, Mr. Speaker, is owed to honorable members of this House. And I would not let this moment pass without expressing it in full. Honorable members have carried this bill the whole of its long way, from the first reading, through a second reading debate, through its examination clause by clause, to the confirmation of the Senate's amendments, a legislative process that did credit to Parliament. Members from every province and from both sides of the House engaged the supreme law of the land with a seriousness the nation could witness. And for that work, I thank them. And thank them each and all with great appreciation. That commitment did not end when the House rose. The work was nearly done when the recess fell, and honorable members were under no compulsion to return. The calendar had released them. They were called back, and they came in the midst of their recess to finish the historic work they had begun. Nothing in that is taken for granted, Mr. Speaker, sir, and the Honorable House should never take it for granted. And they came to work. That is the final proof of a commitment to national duty that no words of mine can improve upon. Because they came, Mr. Speaker, and because they finished the job that they started, the House is now free of the bill. When honorable members return from their recess, they will return to a clear table. The matter that called them back is settled and behind them, and they may take up the rest of the pressing business of the House that gave way to it. What the House has done, Mr. Speaker, is its constitutional duty. It has made law. That is the one task the Constitution places in the hands of this honorable House and of no other. And in discharging it, the House has done the highest thing a parliament can do. The law it has made will enable the progressive building and development of this country. The steady work that a settled constitutional order exists to make possible, undertaken for the Republic and for no individual at all. What was decided here, Mr. Speaker, was decided not for today, but for those who will come after, the beautiful Zimbabweans not yet born, who will one day live under it. History will vindicate them, for what is done for posterity is not judged by the present, but by the verdict of the years to come, Mr. Speaker said. The House has listened, it has debated, it has decided, now it has finished the business. It was called. It came, it asked, and it answered. It began a great work, and it carried it through. The honorable members who did so have my lasting gratitude. I do not doubt, Mr. Speaker, the gratitude of the nation and of those who will come along after us. I thank you, Mr. Speaker, sincerely, and I now move that the House do now adjourn.
It has been moved that the House do now adjourn. Is there any debate? I put the question that the House do now adjourn. Those of that opinion will say aye. Those of the contrary opinion say no. I think the ayes have it, the ayes have it. The question is accordingly affirmed and the House is adjourned. To what day, Honorable Minister?
To the 7th of July, Mr. Speaker, sir.
Thank you very much. The House is adjourned accordingly. May I be allowed to lead the procession in silence?